This is what happens when a mountain of excuses collides with a wall of judicial patience that has finally run out. In the hot seat is Terrell Allen, a man with a history of burglary and drunk driving who's back in court for violating his probation. His defense attorney is about to spin a tale of mental health struggles, panic attacks, and even a freak snowstorm to explain why his client went off the grid. It sounds sympathetic, almost believable, but this judge has heard it all before. She's about to cut through the noise with one devastating question that completely shatters the defense's narrative. Pay close attention, because we are about to witness a masterclass in accountability where a defendant who was given every possible chance to succeed learns that some excuses, no matter how well told, simply can't save you from prison.
Definitely has severe issues. He's been diagnosed, my understanding, from dealing with his family with bipolar depression, as well as what I can see in my interactions with him is that very high levels of ADHD, being able to focus. And so what happened on that day was he was extremely worried, didn't know what to do, panic, couldn't deal with all the problems going on in his life, and decided to freeze.
Burglary of a habitation on March 19, 2019 for a period of 3 years. Is that you?
Yeah, yes, sir. Yes, Your Honor.
All right, state.
Judge, we also have...
Mountcastle, what are you doing? It's Mountcastle.
Okay, yes.
There's another motion to revoke.
Oh, there's a second motion?
No, there's a second case. It's a DWI.
Oh, I have it.
Yeah.
And the court is also calling 2019 CR 10147W. Did you review the motion to revoke community supervision in that case as well?
Yes, Your Honor.
Are you the same Terrell Allen who was placed on community supervision in 2019 CR 10147W for the offense of driving while intoxicated third or more on October 11, 2019 for a term of 8 years? Is that you?
Yes, Your Honor.
All right. And excuse me, could I get a file stamp for motion to revoke? And state, are you proceeding on the same allegations in each motion?
Yes, Judge. The state intends on proceeding on one, waiving and abandoning, if you would, when the state can make that announcement.
All right, you may proceed.
So,
Oh, you're welcome, Mr. Payne.
for cause number 2015 CR 3927, the state will proceed on violation of condition number 2, but the state will waive and abandon the other violations alleged.
Any objections to the waivers?
No, Your Honor.
And then in cause number 2019 CR 10147W, the state will proceed on violation of condition number 2 and waive and abandon the remaining violations, Your Honor.
Any objection?
No, Your Honor.
All right, and state if you'll read the violation into the record, please.
Yes, violation number...
And there it is. True. By pleading true to the violation, Terrell Allen has just made a massive strategic gamble. He's admitting on the record that he failed to submit to a required drug test. This isn't like a criminal trial where the state has to prove guilt beyond a reasonable doubt. In a probation revocation hearing, the burden of proof is much lower, and by admitting fault, the defendant essentially skips the did he or didn't he part and jumps straight to the consequences. His fate now rests entirely in the judge's hands. The state is no longer required to present any evidence of the violation he's confessed. Now, the only thing left to argue is the punishment, which, as the judge clearly stated, could be up to 8 years in prison. The defense is betting on mercy, but they've just handed the judge all the power.
2 for both cause numbers on or about the 24th day of February 2022 in Bexar County, Texas. The defendant, Terrell Allen, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that violation in each of the cause numbers, true or not true?
Sure, Your Honor.
Did you understand by pleading true to violation of condition number 2 and cause number 2015 CR 3927, the court could find it to grant the motion and sentence you up to 3 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 2? Court will find violation of condition number 2 true. And cause number 2019 CR 10147W. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, and sentence you up to 8 years in the prison?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 8?
Condition number 2.
I'm sorry, condition number 2. Knowing that, do you still wish to proceed with your plea of true to violation of condition number 2?
Yes, Your Honor.
All right. Then the court will find violation of condition number 2 true. Is there a proposed agreement?
There is, Judge.
Yes.
It is different recommendations for the two cause numbers. For cause number 2015 CR 3927, the state is recommending termination unsuccessful, but defendant has already been sentenced on that one. The recommendation for cause number 2019 CR 10147W, the state is recommending continued probation, but to complete state ISF cognitive track followed by ISP.
All right. So are you saying that he's already been sentenced in cause number 2015 CR 3927?
The state does see that this is the second MTR and defendant was adjudicated from deferred.
Okay.
That's what we're under the impression of.
Yes, no, he's on regular probation or community supervision. And so his maximum sentence is 3 years in that cause number. So probation?
Judge,
With the first older probation case terminated unsatisfactorily, the stakes are now fully concentrated on the more serious charge, the felony DWI from 2019, which carries an 8-year potential prison sentence. The prosecutor has made their recommendation clear. Continue his probation, but send him to a highly structured cognitive therapy program known as ISF. Now the spotlight swings to the defense. This is their moment to argue for leniency, to explain why Mr. Allen violated his probation. The attorney is about to lay out his client's side of the story, and he's coming prepared with a narrative designed to evoke sympathy and downplay his client's responsibility. He's going to bring up a snowstorm, mental health diagnoses, and a state of pure panic. The question is, will this story be compelling enough to persuade a judge who already seems skeptical?
number, that case expired March 18th of 2022. The court is aware of that.
All right. So and cause number 2015 CR 3927, the court is finding it true. The court will terminate you unsatisfactorily. And just one moment. All right. So then let's move on to the 2019 CR 10147W. State you're requesting ISF?
Yes, Judge. Cognitive track followed by ISP.
All right. Defense?
Your Honor, Mr. Allen, back in 2022, that was the day where there was an extremely bad snowstorm that occurred, and so they called him in to do a test, and he expressed that he didn't feel like he could do it safely that day and wanted to do it a different day. And so we made the decision not to do that. My client owned all of the evaluations. We looked at it, but probation has never been evaluated for mental health issues. Yet in dealing with him and talking to his family, he definitely has severe issues. He's been diagnosed, my understanding.
This is a critical turning point. The defense attorney has presented his case. His client missed the drug test because of a dangerous snowstorm and a subsequent panic attack fueled by his ADHD and bipolar depression. He's painting a picture of a man who made a single mistake on one bad day. But watch the judge's reaction. She listens patiently, but her follow-up questions are like surgical strikes. She's not just taking his word for it. The defense has built its entire argument on the idea that this was an isolated incident, a moment of weakness. But the judge seems to sense there's more to the story, and she's about to pivot from the excuse of a single day to the reality of a much, much longer timeline. The foundation of the defense's argument is about to crumble.
From dealing with his family with bipolar depression, as well as what I can see in my interactions with him, is that very high levels of ADHD, being able to focus. And so what happened on that day was he was extremely worried, didn't know what to do, panic, couldn't deal with all the problems going on in his life, and decided to freeze and not know how to deal with that.
I'm sorry, what are you talking about? I'm sorry, what are you talking about? I'm sorry, what are you talking about?
And he hasn't had any issues since then. We think that the proper thing to deal with in the situation is to address those mental health issues now, and that he will be successful in the remaining terms of his probation, and that's what the freeze up was. It wasn't an issue.
Boom. That's the knockout blow. You've been missing since 2019. With that one sentence, the judge completely dismantled the defense's entire narrative. The story about the snowstorm in 2022, the panic attack, the icy roads, it all becomes irrelevant. This wasn't about one missed appointment. This was about years of non-compliance. The judge's logic is brutal and undeniable. If he could find a way to get to the grocery store between 2019 and now, he could have found a way to contact his probation officer. By comparing his failure to report with basic life activities, she exposes his excuses as a matter of priority, not inability. He wasn't paralyzed by fear. He was simply avoiding his legal obligations. This is no longer a hearing about a mistake. It's a hearing about a conscious multi-year refusal to follow the court's orders.
Of him using or being dirty, it was him legitimately being afraid because of the conditions on that particular day in terms of it being icy. And so we think that this is an appropriate way to remedy both of those situations, is to continue letting him be successful, but also with a cognitive track addressing the issues.
Thank you, may be excused.
Thank you, Judge.
Yes. Yes.
On the icy day, I have the 2 kids, right? Of course, the kids have a mom. Mom was in medical school while mom
I'm sorry, what are you talking about?
was at the hospital. I only had
Just when you think things can't get any worse for the defendant, he derails the proceedings with one of the most bizarre and self-sabotaging tangents imaginable. Hey man, you sound white. In a desperate attempt to connect with the judge or perhaps explain his own complex identity, he brings up this completely irrelevant and racially charged comment he claims to receive. Notice how expertly the judge shuts this down. She doesn't take the bait or get drawn into a debate. Instead, she turns it back on him, identifying it for what it is, a reflection of other people's prejudice and something that has absolutely no bearing on the legal facts of his case. This was a massive misstep. It made him look unfocused and out of touch with the gravity of his situation, doing nothing to help his case and likely eroding any remaining sympathy the judge might have had.
me. It was me, the 2 kids, right? And of course, everyone sees save the last dance with Julie Robert. Or yes, okay, yeah. I can't drive. You know, I don't want to take my kids to a, you can't take your kids anywhere, can you? No, so I was arguing with the probation officer. I was like, can I please go tomorrow? She's like, no, Michelle, and I have to go.
Okay, so here's the thing. You've been missing since 2019.
For this day.
So, but here's the thing. 2019, do the math. How many years?
With the defendant's own excuses falling flat, the defense attorney shifts tactics. The strategy is no longer about logic or explaining away the timeline. It's about pulling at the heartstrings. They are calling Pamela Williams, the defendant's grandmother, to the stand. This is a classic move in sentencing hearings, bringing in a respected family member to paint a more human picture of the defendant. The goal here is to reframe him not as a defiant probation absconder, but as a troubled, mentally ill grandson who has genuinely changed, even if he can't handle his responsibilities. The defense is hoping that her raw, emotional testimony can succeed where their legal arguments failed and persuade the judge to see the man, not just the rap sheet. This is their final emotional appeal for mercy.
Have expired since 2019 and you still haven't come in. The only time you came in was because you were arrested.
22.
Right, Your Honor. And dealing with, and we can present testimony on this, Your Honor. I've talked to his family, interviewed them.
No, I'm just trying to let him know
Right.
that what he's given me are excuses.
Absolutely.
And these are life. This is life, right? Everybody has different things they have to do in life, right? Now you have some people who say, oh, I'm not going to go to the store today. I'm not going to do this, but there are no real consequences for that. I mean, you don't have something to eat that day. But the consequences are you could potentially go to prison. So since from 2019 to now, have you gone to the grocery store?
Yes, sure.
All right, so you found a way to do that, but you didn't find a way to contact your probation officer and come in. Since 2019 to now, have you taken your children to school? So you haven't taken them to school, so that means somebody else was taking them to school, so you could have come in. So don't come to me with excuses because you haven't done anything since 2019. You understand? Probation, what are you requesting?
Judge, the recommendation on Montgomery date item though.
I mean, he hasn't been around since 2019.
We're under the impression it was 2022 when he failed.
Was
All right, so that's still not good because that's 3
He
years.
he was on the very last end of drug court. In fact, he was waiting for the certificate to graduate from the drug court.
No, and see, that's the other thing with drug court. I know they give people chances, and I know from drug court, and you correct me if I'm wrong, when you don't show up for something for drug court, they don't immediately put you out of the program. Yeah, but they can't help you if they don't see you.
I appreciate you for recommending me to drug court because that helped me out in my adult life, my full life period. Discover a bunch of things. I didn't realize I had a problem. I always thought, oh, you gotta have. I just didn't want to stop, And
No, I told you had a problem. That's why I sent you to drug court.
I appreciate that, Your Honor. It helped me out tremendously. It's like I always thought I was Superman. It's like, I'm.
The grandmother's testimony was powerful, heartfelt, and undeniably sincere. She spoke of her grandson's deep-seated mental health issues, his positive changes away from crime and drugs, and her belief that he doesn't need punishment, but help. From her perspective, he's a good boy who just recently realized the depth of his problems. Any other judge might be swayed by such a moving plea from an elder, but this judge isn't just listening to the emotion, she's preparing to respond with cold, hard facts. She is about to deliver a calm, respectful, but devastating rebuttal. She's going to explain to this loving grandmother exactly what kind of help was offered, how intensive it was, and how her grandson was the one who walked away from it. This is where compassion meets accountability.
How many times have you heard I'm pretty sure I get this a bunch, right? It's like, hey man, you sound white. I'm like, I speak English.
No, I don't get people saying I sound white. If they say I sound white, then that's their prejudice that's coming out. Because what does that mean to sound white? What are you trying to say?
I get it all the time. I'm sorry.
He's talking about himself, Your Honor.
No, okay, so he needs to sign the trial court certification. He hasn't signed that. And probation, did he pay the $57 restitution to SAPD? All right, state.
Yes, Judge.
All right, the court is going to grant the motion. Do y'all want to speak to years? His minimum is 8 years.
Judge, that is the full range. The state has no comment on the range.
All right, thank you. Maybe excuse. Yes.
Have you be permitted to present some brief testimony?
Sure.
Okay. I'd like to call Pamela Williams.
Ellen,
Pamela Williams.
you're back again.
They call her.
Hello. Hi. Hi. Can you raise your right hand for me, please?
This is an absolutely masterful moment from the judge. Instead of just ignoring the grandmother's plea, she addresses it with profound respect and clarity. She meticulously lays out the history of the case, explaining that she knew the defendant needed help, which is precisely why she sent him to the intensive felony drug court in the first place. She describes the program's wraparound services, the dual diagnosis track for mental health, and the probation officers who literally go out searching for people who fall off the wagon. She makes it painfully clear help wasn't just offered, it was aggressively provided. Terrell Allen wasn't a man the system failed. He was a man who failed the system that was trying to save him. The judge isn't just sentencing him, She is educating his family on the reality of the opportunities he squandered.
Please, do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand if you'll state your name for the record.
Pamela Williams,
All right, defense, you may proceed.
How are you related to Mr. Allen?
my grandson.
And you've been part of his life the past 10 years.
Yes.
And so when he first was placed on probation and then did not go in probation, what type of things did you see in terms of what was going on in his life and his ability to deal with problems?
Well, Terrell has been having, we've been telling him Terrell has been having mental problems for a while. He don't deal with things good, depression, bipolar episodes, different things like that. We've been trying to get him to deal with. I think I spoke to you and told you that he just needs some help, you know. As far as I know, I've been trying to help him. He says he's gonna do one thing, and then, you know, he bounces back from another. So we've been trying to help Terrell get this thing situated. But I think Terrell needs some help. I'm his grandmother. If I thought, I'm this type of grandmother. If I thought he was a menace to society, I'd tell y'all, do what you gotta do. But Terrell needs some help, mental help, Judge.
Mm-hmm.
He really does. And
Even now, with the judge recounting his multiple failures and the extensive help he rejected, the defendant can't seem to grasp the concept of full accountability. His response, "I feel just for you know," is vague and trails off. Another missed opportunity to offer a clear, sincere apology or acknowledgement of his actions. He's been given chance after chance to own his behavior, from his lawyer's excuses to his own bizarre tangents, and now this final weak statement. The judge has laid out the entire history of his second, third, and fourth chances. The time for talk is over. The court is granting the motion to revoke his probation, and the only question left is the one that matters most. How many years will he spend in prison for squandering it all?
sometimes they hide things from me. I'm grandma.
Mm-hmm.
But I've noticed things. You know, he's been through really bad depression. But I think he just needs some mental help. And
Let me ask you, there's a time where he was making poor decisions with the burglary and the DWI. Have you seen changes in him where he's staying out of trouble and not hanging out with the bad friends?
he's changed. He's changed. He's so changed. He stayed locked up in a room all day. And so we were even afraid that he was going to, you know, do something.
The defense makes its final plea. Acknowledging the court's decision, they ask for the absolute minimum sentence, 2 years. Their argument is that he's finally in a good place mentally and that a shorter sentence will allow him to get back to society sooner and build on his supposed progress. This is the last-ditch effort, framing a shorter prison term as the most rehabilitative option. After everything we've heard, the years of absconding, the rejected help from the drug court, the flimsy excuses, the defense is still pushing the narrative of a man who has turned a corner. The judge has listened to everyone. She's heard the excuses, the emotional pleas, and the hard facts from the probation record. Now it all comes down to this. Will she accept the defense's argument for minimum punishment, or will she send a stronger message?
He's changed. He's really changed, but he just needs some mental help.
Have you seen the alcohol or the drug issues that were going on?
No. He doesn't have any.
And you saw that before?
Sure, yeah, I saw it before.
And you haven't seen that now?
No, because I told him when you're a child.
3 years. The judge lands between the defense's request for 2 and the maximum of 8, imposing a significant prison sentence while still acknowledging his potential for rehabilitation by requesting a therapeutic community. Ultimately, this case was a stark lesson in accountability. Terrell Allen and his defense presented a narrative of victimhood, a man paralyzed by mental illness in a snowstorm. But the judge, armed with the facts, methodically dismantled that story, revealing a multi-year pattern of avoidance and rejected opportunities. The emotional testimony from his grandmother was moving, but it couldn't erase the reality that help was offered and refused. In the end, the court affirmed a powerful principle: while the system can offer endless chances for help, it cannot force someone to take them. What did you think of the sentence? Was 3 years fair, too harsh, or too lenient? Let us know in the comments below, and subscribe for more courtroom breakdowns.
He behaved as a child, but become a man, you gotta put away some things. So I haven't seen those things. And like I say, he really does, Your Honor. He has some problems, some issues that are not I say, a menace to society. I think he just needs some help.
Mhm.
And I tell them, I'm the type of grandmother that I tell them the truth about things. I'm telling you the truth. I really think he needs some mental health. Terrell is not, I guess you hear this all the time. Terrell is not a bad boy.
Mhm.
He's not. And I just think he needs some help. And we ask, that's just.
And if whatever the judge decides to do, whether it send him to prison and he gets out or gives him the help, you don't see the problems in him that were going on back with it. So you're not concerned about alcohol or drug abuse
No, not at all.
or the criminal behavior.
Oh, no, not at all.
Okay, I pass it.
Not at all.
All right, any questions?
No questions from the state council.
All right, so this is what I want you to understand.
Yes, ma'am.
I appreciate your coming down and telling me things about him,
Yes, ma'am.
but I don't want you to go away thinking that help wasn't offered to him, because the felony drug court where I sent him, they have a dual diagnosis problem. So they check for mental health issues. They will give them mental health help. They will give them help with their drug addictions. They do all of that. It is a global wraparound service
Okay.
for people who are in that program. And that's why I sent him there. And felony drug court is different, and these treatment courts are different from different courts, right? From your regular courts, I should say. Now, of course, based upon my knowledge, I will use what I've learned from the different treatment courts in this court sometimes. You know, I see if somebody has mental health issues or if they have a drug issue, then I try to get them help for that.
Right.
And I always tell people, if you have a drug issue, mental health issue, and you let me know about it and I don't give you anything to help with that, then that's my fault. But if you tell me, I'm fine, there's nothing, right? So with regards to your grandson, I knew the issues he had because he was on probation in this court for 2 cases. And that's why I sent him to felony drug court instead of revoking him at that time. Now, felony drug court, when people miss reporting and they go missing, because sometimes people will, what they say, fall off the wagon, go back to their old ways. They will do their best to work with them and try to find them. They have probation officers who will go out to wherever their old haunts were. They will walk, they will go on corners, everything to try to find them, to get them back in compliance before they issue a motion to revoke. So when these treatment courts do a motion to revoke, they've tried everything. There's nothing else for them to do. So I want you to understand that he was offered the help. And he was in felony drug court. And he didn't follow through.
Yeah, speak.
Sure.
Well, I was thinking sometimes they don't really, you say he need help. Everybody say they need help. But sometimes it takes a while for them to realize that they really need help. I mean, really, seriously. For a long time, he didn't think he needed any help.
Oh, no, I understand. That is why.
Everybody was saying he needed help.
No. That is why when he picked up a new charge, because he was previously here for a different felony case. And then he ends up picking up a DWI. That's why I didn't revoke him, because I knew he needed help.
Right.
And that's why he went to felony drug court. And felony drug court is intensive. They have something they have to do every single day. So, you know, you can only offer somebody so much help, and then when they don't follow through, they don't follow through.
Like I said, I think Terrell didn't know.
Okay.
I'm serious, because we've been telling him for years that you need help. But I think he was in the mindset that I don't really think I need help.
Okay.
You know, and I know you said you probably sent him different places, and you saw it. I saw it.
Yeah.
His parents saw it. But I think he just finally began to see it. He really needs help.
Okay.
He really needs help. And I'm asking you, he really needs help.
All right.
Well, I give him a chance.
Well, I appreciate you for coming down and telling me things about your grandson.
Okay.
All right. Thank you.
Thank you.
You're welcome. Do you have any other witnesses?
No, the witnesses are.
All right. If you'll come forward. All right. So, Mr. Allen, you know that the court has given you a chance, more than one chance.
You helped me out a lot.
Yeah. You were on probation. Then you picked up a new felony. Then I sent you to felony drug court. And felony drug court, they have a dual diagnosis program to work with you with mental health, to work with you with drug issues. Felony drug court, when you, and anything I'm saying, if it's incorrect, let me know.
I don't think my grandmother was.
Yeah. No. I'm not talking about, what I'm saying now, if what I'm saying is incorrect, let me know. Felony drug court, when you get out of compliance and you go missing, they send people out to try to find you, to bring you back in.
I love Judge drug court. Judge Glenn for mayor, you know, I love Judge Glenn.
All right. So,
Finished felony drug court. Just need to.
Yeah. okay. All right. The court is going to grant the motion. The court is going to order therapeutic community, give you credit for any time served. How much time are you asking for, counsel?
With credit for time served,
Yeah, you get credit for time served.
we haven't.
So the range of punishment for him is anywhere from 2 to 8 years. How much are you asking for?
Oh, in terms of being sentenced? Okay,
Mhm.
we're asking for 2. And let me tell you why we're asking for that, Your Honor, is because you heard from the testimony that, you know, he's turned his life around. He just has an extremely poor decision-making process. And we think the sooner he gets back in society, the sooner he can build off of where he is now, which is understanding of what's going on. And I think if the court chooses to punish him with that, which we would understand and appreciate, the lowest number to allow him to jump back into society, see his kids, and build off of the good place he is in his life right now would be the best thing for him. So we're asking for 2 years. All right.
All right. I'm going to sentence you to 3 years in the prison, give you credit for any time served. I'll request a therapeutic community for you. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
We just now talked about it, Your Honor. I can go over it.
All right, because this is because this is not a plea bargain agreement, you do have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Sure.
All right, good luck to you when you're released from prison. If you need anything and I'm here and you need help, just let me know.
May I ask him if that time I have?
Sure. Huh?
May I ask him?
We'll find out. I'll tell you.